You're charged in an indictment here, which carries with it up to 10 years imprisonment for victimizing Debbie Avila.
I understand that, John.
So right here now, you're worried about her well-being?
Yes.
Really? Really? Why weren't you worried about her well-being being August 4th through August 25th of last year? When, let's see, you threatened and harassed her by texting and stating you hated her, threatening to fight her, and that you would urinate on her grave?
Judge, we're waiting to see, I know this is kind of backward, but we're waiting to see what the misdemeanors do on this, because the felony is apparently an aggregation of the two misdemeanors that are still pending in misdemeanor court. I think the state's willing to let him handle the misdemeanors, and then if those get resolved, it's just miss the felony. I think it's the plan for Mr. Oliver. Okay.
Can't believe I got to the point where I'm waiting on misdemeanor courts. I mean, that seems backwards. But what do y'all agree to do?
At this point, just
Things
said it doesn't handle the.
It hadn't made sense for about 19 and a half years anyway. This is not a science. Renee Avila,
Yes, John.
26 CR 273, you were charged with a third-degree felony of violating bond or protective orders. Engaging to communicate directly, you improperly directed communications to Debbie Avila, a protected individual, texting her, repeatedly calling her on the phone, repeatedly going near the residence. Okay. All right, the grand jury indicted this. Y'all want me to get involved in this or not?
If we can get it reset one more time.
Why did the grand jury indict it? Do you think?
Would be the state's call, not mine.
All right, what about it, Frank? Why did it get in here?
The state's not saying that it didn't happen. I did agree, Judge, to see what's going on with the misdemeanor cases and try to take care of everything at one time. Well, everything with one.
Yeah, but now, what are we waiting on? Why are we waiting on anybody? I thought we were a more serious jurisdiction. I think we are.
We are, Judge.
So, I mean, I'm old enough to make independent findings.
Judge, I guess if this one, we're just asking for one more recess, so Mr. Oliver can handle the misdemeanors, and then if he doesn't, then we address it. Paul, I guess.
And a reducement in my bail. That's what I'm sitting around for 5.5 months.
I didn't understand what it said.
Even once I'm on here.
See, that's why,
Sorry.
that's why we move forward in this court and we have bond hearings.
It's been 5.5 months now.
So, conduct a bond hearing.
That's right. Fingers to you see it.
I got my wife and kids at the homeless shelter that are waiting on me to give my taxes.
Say it again?
My wife and my kids are at the homeless shelter in Portland with Mrs. Pat, and they're waiting on me to get out so I need my taxes so I can get them out of the homeless shelter.
What's your wife's name?
Debbie Avila. So there's
Well, hold on.
Yes, sir. Yes, Judge.
You're charged in an indictment here, which carries with it up to 10 years imprisonment for victimizing Debbie Avila.
I understand that, John.
So right here now, you're worried about her well-being?
Yes.
Really? Really? Why weren't you worried about her well-being being August 4th through August 25th of last year? When, let's see, you threatened and harassed her by texting and stating you hated her, threatening to fight her, and that you would urinate on her grave?
This is the moment that reframes the whole case. Up to this point, he's talking about missing his family, wanting a plea deal, but then the judge reads exactly what he's accused of texting her, and it's brutal. That's the gap the judge is pointing out. The concern for her well-being now doesn't erase the specific threats he's charged with making.
Let's see, knowingly and repeatedly calling her phone multiple times over several days, and knowingly go to and near the residence that you were all this time ordered
She's
Not-
not my wife, Your Honor.
You interrupted me, Mr. Rude
Oh,
Man.
sorry. I apologize, Your Honor.
Yeah, and we can't, see, it's just not rudeness, but when two people speak over each other, this court reporter can't take two people, and the Court of Appeals has said that if she can't do her job, someone gets in trouble because they are unable to figure out what's being said. And they are the ultimate determiners when a case gets appealed.
Yes,
So
sir.
I don't want to make them upset.
Yes, sir.
I want them to be able to do their job, so it's not going to be my fault. And nonetheless, these are serious allegations that the grand jury brought. And you're concerned about their well-being now doesn't favor this court in any way. I'm more concerned what the grand jury did. All right. What's the state asking in this case?
Judge, I did just make a prison time offer to defense counsel. So I'm not sure if he's ready to make an announcement on that at this point.
Do you know, have y'all had a chance to talk with that, with her?
Not with the offer, but I mean, is,
Well, we're not going to conduct a plea negotiation on YouTube with thousands of people watching. Get with me on that. Talk to them and see what y'all are going to do and what step we're going to take next. But I will do this. I protect people who are threatened, especially folks who state they will urinate on the loved one's grave. Shame on you for that. That's just terrible.
Your Honor, can I speak to you, sir?
No, if you speak to him, he's your lawyer. He gives you advice. Y'all go there. It's on you, food. Come on. We'll go to something else and let me know when you're ready. But yeah, don't be.
Small but important moment. Here the judge cuts off the defendant trying to get legal advice out loud, live, in a public hearing being streamed. Attorney-client conversations are supposed to be private for a reason, and the judge is protecting that, not brushing him off.
Doing advice giving on you want everybody to hear, then kind of ruins this sanctity of confidence between the defendant and the lawyer. And that's
he would like to reduce his bond.
okay. Avila,
From $30,000.
Yes, Your Honor.
oh no, yeah, he's right here. He was here before.
Yes, sir.
Today. All right, we're staying.
At the last.
That's,
That's me.
'26 CR 273, this is call. The defendant Renee Avila is here. He's with Mr. Turk, his attorney, and state's attorney. Defendant is charged with a third-degree felony of engaging in conduct two or more times that constituted an offense under the Texas Penal Code. And by communicating directly with the victim in a threatening, harassing manner, texting, stating the defendant hates her, threatening to fight her, and he would urinate on the grave. Yeah, that's knowingly and repeatedly calling the victim's phone multiple times and going to and near the residence of the victim. And this constitutes, according to the grand jury, a engaging in conduct two or more times, which is a violation of bond or protective order rules, and thus is a third-degree felon under the Texas Penal Code, section 25.07, which states, among other things, that It's an offensive in violation of a condition of bond set in a family violence matter. It directly communicates to a protected individual or member of the family or household, or threatens, and those are yes statutes that the legislature enacted to keep the family unit from being placed in violence. Okay, so what do you ask?
Mr. Allen is it Allen? Oh, that's what I thought. Is asking to reduce his bond to say $15,000 so we can get back to work. You know, not necessarily to support his family indirectly, because I mean, they need support. He's not supposed to contact his, I guess, ex-wife's wife.
She's my wife.
But, directly, but he does have an obligation to his children to support them.
I have an obligation to her too.
He does, and I mean, but he can't contact her because of the pending cases. So that's what I'm saying, Judge.
Well, whose fault was that?
Well, Judge, this is a bond hearing. He does have.
No, the point. No, the point.
I understand what
You're asking for a reduction in bond, which would be him being a reduction of his requirements for being released. But he didn't follow the court's rules in the first place. That's why he's here. Why would he follow them now? If I reduced his bond, why would he follow any rules? I mean, he's in the grand jury indicted him. Probable cause was rendered that he did not follow the bond or protective orders of a court.
This is the core tension of the whole hearing. He's asking for less restrictive bond conditions by essentially promising better behavior, but he's in this exact courtroom because he already broke the last set of conditions. The judge isn't punishing him twice, he's just pointing out that the request kind of undercuts its own argument.
That is the allegation, Judge.
Well, why would I think he would follow any I would guess?
You want me to speak, Your Honor?
I don't care what you do. I'm just making a comment.
I would definitely follow the orders because,
You mean like,
no, because
but you're here for a different reason. You're here for violating orders,
Yes, Your Honor. I understand, John.
What's Stacey say?
Judge, if the court is inclined to grant the bond reduction, I'm going to ask for a GPS monitor before he is released, as well as no contact with that our complaining witness. But I am also looking at his history of non-compliance, and I did not have an opportunity to do any additional research as to his bond release.
No. Your request is denied, but I'm going to try to move this thing fast. When can y'all be ready for something? A hearing, a trial? Because he's been
He wants a trial?
sitting around a while.
At this point, yes.
Okay.
How long you been in jail?
5.5 months, so.
So I guess we'll just reset it for trial, Judge.
Okay, so I'm placing on the trial docket, okay?
Yes, sir.
Let's try to get that done that way. Thank you. That is all. All right, we call 26 CR 293, the state of Texas versus Leslie Kurt Foreman. You're Mr. Foreman? And you were here with Mr. Adams, your attorney and the state's attorney. I'm looking at this file here. And this is an indictment charging you with failing to comply with sex offender registration, which you've only been convicted 4 or 5 other times of that. So you know that it's got ramifications. It's got requirements. Because you've been convicted failing to register in 2004 out of Faulkner County, Arkansas, failing to register out of Faulkner County, Arkansas in 2009. After that 2009 conviction was final, you committed the offense, it says, of failing to register and were convicted of that felony in 2011. After that was final, you were convicted of failing to comply with sex offender registration for life and were convicted of that in 2020 out of Bowie County. You've been an habitual felon at least three convictions ago. So you're looking at 25 to life. You understand? All right. That's just so you know. And this is what this alleges is, once again, you're accused of failing to comply with sex offender registration in this county. And so you're not eligible for probation, and your minimum sentence is 25 years to life. Do you understand all of that?
Yes, sir.
All right. So what else? Did you want to put something else on the record?
Yeah,
Go ahead.
yeah, just often the case is 10 years. He is aware that he's habitual, looking at 25 to life. He did not want to place the case on the trial docket. I think that he needed a little bit more time to digest the offer and just wanted one more announcement, but he did not want to reject the plea offer, and he did not want to set it on the trial docket. I think he had some affairs that he needed to get in order. So that's what he was asking for. But I did.
Well, he doesn't work on his timetable. I mean, this thing's been indicted since February 16th.
I didn't know that.
It's going for it's 5 months old right now.
How about start 2 weeks then? Just two.
I got one.
One is perfect. We'll take that. One will be fine.
All right, you've had more than enough time to think about it.
Thank you, sir.
You had 1 week.
Thank you, Judge. Appreciate you. Thank you. I'll live in.
The defense wanted more time to consider a 10-year plea offer, but the judge points out the case has already been open for 5 months. That's a good example of a court balancing fairness, giving someone real time to make a serious decision against just keeping cases from stalling out indefinitely.